going to get started with our protection order calendar. Lillian Vaughn versus Jordan Gorin. Petitioner Lillian Vaughn, final call. This is number 25-278. All right, and Ms. Gorin, you're present, correct?
Yes, Your Honor.
Yeah, it looks like you did get notice for this hearing. I know you're involved in another one, but another two, I should say. But this one, 25-278, will be dismissed as the petitioner has not appeared. Okay, so that one, 25-278 is dismissed. Next case with one party present is Angela Marinella. Would you mind having a seat at the table there? Yep. And then the respondent in that case is Sherry Grimes.
Doesn't look like she's here.
Okay. 25-281. Looking at my court file, it does not appear that notice of the hearing has been served on Ms. Grimes.
Okay.
Okay, so would you like me to reset this to give you an opportunity to get her served?
Yes, but I'm wondering if I can ask a question or two.
You can ask a question, sure.
The day I got the order,
which was August 15th
on a Friday, which was the day after the incident, I was getting in my car with the order in my hand, and the officer called me and told me he had just arrested her again for assaulting her grandfather. But because of things he knew about her, instead of taking her to jail, he took her to St. Peter's.
All right.
And then they removed her to a facility in Marysville. I've been in touch with her mother, who said that as of Saturday, she didn't know she'd been let out or not. And the officer who called me right after I got my order, he met me and I gave it to him, and he said he would serve her, but he was unable to do so. So he gave it to his desk sergeant. So it is unknown whether or not she was released on Friday. She had a court hearing at the facility on this last Friday. And so her mother said that when and if they release her, she has to provide an address. But I don't know if her mother is allowed to have that address or not. And I don't know if the police have it. So my question is there a way I can obtain that information and tell the police so they can serve her?
Yeah, I won't be able to answer that for you. But I'll tell you, if she's committed because of a mental health reason, there's privacy rules around that. And the institution where she is, they won't disclose that to law enforcement or anybody else.
Oh, really? Okay.
Yeah. So, but again, I don't know what the circumstances of that are. So that's not, you can't take that as legal advice.
Okay. Because of the situation, I would like to request, I don't remember the term you used, but some more time so that perhaps she could be served.
I've reset your hearing to September 8th.
Okay, and this is my last request, respectfully. I'm going to be out of town, and as soon as I could come would be September 15th. Is that possible?
I can only extend the hearing 2 weeks since a temporary order was issued.
Is it possible for someone to come for me?
Yeah, you can hire an attorney to represent you for the hearing.
Huh.
Or you can do it by Zoom.
I can do it by Zoom?
Yeah, you can see there are a number of people on, you can't see the screen right now, but on my screen, there are a number of people. Yeah, you can participate in the hearing by Zoom. That's perfectly okay.
I don't suppose you happen to know if you can do it from another country?
Sure.
You can? How about that? Is there instructions
from anywhere?
Is there instructions for that?
It's on the information that we've already given you. There's a Zoom instruction sheet
on my restraining order thing here?
In the packet that you were given when you initially filed the case. Yep, there's Zoom instructions in there.
Okay, so that would be.
You can call in from anywhere.
Okay, and did you say September 8th?
September 8th, which is Monday, just like this, also at 9 o'clock. And if you're somewhere else, make sure you remember the time difference. Because if if you don't show up at 9 o'clock
Oh, of course.
here,
Okay.
we'll figure you're not here. As you can see, that can result in a case getting dismissed. Yeah, they'll take care of giving you all of that.
So I go
From
to
the
the
counter.
counter and give me a packet?
Yeah.
So it's September 8th at 9
Yeah,
o'clock.
it's right there on the front page of that order.
Thank you.
You're welcome.
That's so cool. That's great. Thank you so much for your time
You're welcome.
and have a good day, both of you.
You as well.
Bye-bye now.
Brian Van Quatham versus Jay Stevenson. All right, and Mr. Van Quatham, would you mind having a seat on this side, and then Mr. Stevenson on this side, which would be your left. This would be case number 25-279. It's got to make a couple notes here. Okay, so Mr. Stevenson, you got served with notice of the hearing and a copy of the petition.
Yes, sir.
Okay, are you ready to go?
Yes, sir.
Okay. All right, so here's how this is going to go, and this will apply to everybody else. So it's probably worth your time to listen to this, but for these hearings, what I'll do is I'll start by swearing the parties in. The person who filed the petition, who started the case, the petitioner, they'll get to go first and tell me why they believe they're entitled to a protection order. And after I've heard from the petitioner, I'll hear from the respondent, and be the same thing. You testified about the situation and why you believe that the person is not entitled to an order. And I'll consider what you've said, and I'll also consider anything that's been filed in your case, the petition, any documents, witness statements, anything like that. And then I'll make a decision as to whether or not to issue the order. That decision that I make will be based on a couple of things. One, the preponderance of the evidence standard. That means the petitioner has the burden of proof. The petitioner has to prove by a preponderance of the evidence that they're entitled to that order under the law. And two, I'm going to apply the law that applies, the law regarding harassment, if it's an anti-harassment order, or domestic violence, if it's a domestic violence protection order, that sort of thing. There are different standards for each one, and I'll explain those as I get to my decision. Okay. So during the time the other party is addressing me about their case, I'll ask you to just please listen, even if you believe the other party's telling me things that aren't true. If you disagree with what they have to say, just don't interrupt them. Don't make a scene. It's not necessary. Keep in mind that you either have already told me your side of the story, or in a minute or two, you're going to get your opportunity to tell me your side of the story. And I expect, as with any case, there's going to be different facts or different perspectives on the case. All right, with that all in mind, then I'm going to ask you, please, both of you to raise your right hands. And do you each swear the testimony that you give in this matter will be the truth, the whole truth, and nothing but the truth?
I do.
Yes, sir.
Thank you. All right, so Mr. Van Quatham, you get to go first.
Okay. This basically all got started after their dog killed ours. That's when this whole thing, I mean, we had our run-ins, yes. But Jay and I did have, a few good neighborly talks here and there. But Jay has assaulted me before. He has spit on me. He put his forehead on my chest before. He has threatened his dogs on us multiple times. I have everything on paper trail. He always wants to fist fight me, and I told him I'm not a fighter. And when his dog killed ours, this is why we're here. Because no one seems to care that our dog got killed by their Roddy, and no one wants to do nothing about it.
Can you tell me when this happened?
I have a paper trail, but it's in my truck.
So to the best of your recollection, when did the dog situation happen?
I do believe June 11th.
This year, June 11th?
Yes,
Okay, now you said he always threatens you. That's kind of vague. Can you tell me specifically any incidents and
he
when
just
they
wants to
occurred?
fight me all the time.
Okay.
He wants to,
I need to ask you a question about that.
okay,
So how do you know that he wants to fight you? What does he do or say that makes you think that he
he
wants
shows
to
me his
fight you?
fist. He said, come on, come on, come on. And I'm getting tired of it.
Now, are you two neighbors?
Yes,
Is that next door neighbors, same
Yes.
apartment complex? How?
no, it's just two houses on a dead end road.
Okay. All right, so Mr. Van Quatham, what you wrote in your petition is this. You wrote, fear the Roddy can escape the cage in the front yard and attack us or dogs. That's all you wrote in your petition.
Yes,
And then for past incidents, you wrote threats and you wrote stalking.
yes. They're always taking pictures of us. I want that stopped too.
So now it's pictures too.
Yes, sir. Every time we go outside, we see a flash on their cameras. They have blocked the road so we can, so it makes it really hard for me to back my truck around. But I always manage to do it. They haven't done that for a while, but they have blocked the road or the driveway. Excuse me. I shouldn't say road, but yeah, driveway.
So is this like a public road or a common driveway?
It's a common road or a common driveway, sorry.
Okay. All right, Mr. Van Quatham, is there anything else I need to know?
I don't think so right now.
Okay, well, there won't be a later, so if there's
Yeah, I
any,
understand.
if there's any other information you wanted to tell me when you came in today, now
Yeah,
is the time.
I'm just sorry about, I'm just getting tired of all the threats. I'm tired of his wife, Teresa, threatening me with a gun. She has done that in the past.
Well, you didn't file for a protection order against his wife. So
Well, we did.
We're talking about.
That's a whole
Mr.
different case,
Stevenson.
though.
All right, I'm gonna let Mr. Stevenson tell me his side of it. Okay, go ahead, Mr. Stevenson.
Good morning, Your Honor. On August 13th, I moved back to the residence. I had moved to Cedar Woolley for 4 months, doing a work contract. During that time in June, I received a call mid-June, around the 15th or so, from Teresa stating that her dog had gotten out of the house, was let out of the house, and ran over to the neighbor's house and got into it and had unfortunately killed their dog. Animal control came out to the home on the 14th of August and inspected the kennel that we installed in the front yard per the requisite of animal control. And they found us to be in compliance and that it to be, they said, the most sturdy and best looking kennel they had ever seen, and that we did a great job, top and bottom covered, full steel bars. Since we were in compliance, I didn't realize that there was going to be any further issue. And then I was served the following day stating what was in the packet, that he felt that the dog could get out of the enclosure and felt threatened by that. Never at any point have I threatened him. Never at any point have I blocked the common easement. What we had done in the past was pulled our vehicles to the edge of our property, to the edge of the easement, to prevent all the vehicles from coming down our road and doing a U-turn in our driveway. The road's supposed to be a through road. It's on maps as a through road. It is not, because our neighbors, Mr. Van Quatham, has a trailer, a Connex, and a swimming pool blocking the road from going all the way through. That being the case, and since the county had not rectified it, we decided to pull our vehicles to the edge of the easement so that vehicles would stop pulling into our property and into our front yard from turning around. But it doesn't stop anybody from getting into their own private properties or from using the easement. There's been a long-standing history of Mr. Van Queetham screaming obscenities and threats, threatening to shoot Teresa, her son, her daughters, myself, my animals. I never took him seriously. So I never escalated it. He called a false report in saying that I had a firearm. I'm a convicted felon. I don't have firearms. I will never try to obtain a firearm. I don't require or want to have a firearm. Neither does Teresa. She doesn't have one in the home, not even in the safe, nor has she ever for the last 8 years that we've been together. That couldn't be allowed. I will not risk my safety or my personal freedom for a person's hobbies or whatever they may have to need a firearm.
Right.
Beyond that, Your Honor, I don't know what else to present. I do not want any sort of altercation with our neighbors. I personally do not want an interaction with our neighbor. None of it has ever been positive. It started on day one. I went over to introduce myself on our first day of getting the property. There was 3 of their guests' vehicles parked over on our property. And I went to introduce myself and was given an eye roll from Mr. Van Queetham as if it was from a child. And then he just started immediately cussing. And I said, whoa, I'm sorry, we got off on the wrong foot. I was just trying to introduce myself and ask that you guys please don't park over here anymore. He continued to scream at me and tell me that the previous owners of the home, before he had died, had no problem with it whatsoever. And I calmly smiled and said, sir, that guy's passed away. He no longer lives here. We own the property now and we don't owe you. And also, you have plenty of property to park your own vehicles on your property. There's no reason to park it in front of our garage. From that point, the relationship was unhealthy. Every time there seemed to be an opportunity for us to talk, it was glares and burnouts in my front yard and stopping and staring into our home, very threatening and menacing like. It was very uncomfortable, to say the least.
Okay.
I would just like for the behavior to stop.
Okay. Well, I think I can address some of this. First of all, with regard to the dogs, that's not a anti-harassment order case. There's Thurston County Animal Services that deals with those situations if there are violations of the animal code. And if you feel like you've been damaged by the actions of his dog, you can bring an action for damages, but that's not an anti-harassment order case. With regard to your easement or, shared or common property, this court doesn't have subject matter jurisdiction over that issue. If you want to resolve the issue about how the easement is used, you would have to bring that action in Thurston County Superior Court. It can't be done here, and it's not an anti-harassment issue. I can't find, based on the evidence presented here, either what's been filed in writing or what's been testified to by a preponderance of the evidence that any harassment has occurred. There is no substantiation to any of these allegations of threats or surveillance or anything like that. There's no proof, no substantial proof of a knowing and willful course of conduct directed by Mr. Stevenson to Mr. Van Queetham that seriously annoys, harasses, or is detrimental to him, or would cause a reasonable person to suffer emotional distress. I do not find those elements. The petition for an anti-harassment order is denied. I'll give you both a copy of that. And the temporary order that the court issued back on August 14th is terminated. Since you're both here, the court clerk will give you copies of the court's order, and then that will terminate your hearing for today.
Thank you, Your Honor.
Yeah, the clerk will tell you when it's your turn to come up here and get your copy of the order.
Thank you.
And the next case is going to be Jamie Connolly versus Jordan Gorin. And you're Jamie Connolly? Okay, so make sure I know who's who here.
Doesn't matter.
Why don't you grab that one right there? And I've got two cases involving you both. There's 25-277. And that's the case, Ms. Connolly, where you filed for a protection order against Ms. Gorin.
Okay.
And then I have case 25-282, and that's the case with Ms. Gorin as the petitioner filing against Ms. Connolly. My intention would be to hear them both at the same time and make a decision in each case rather than doing it as two separate hearings.
Yes. That's fine.
Usually I do it that way. It usually makes sense. So, okay. So let's see. Let me make sure though, Ms. Gorin, that you're ready. I'm sorry, Ms. Connolly, you're ready?
Yep.
And Ms. Gorin, you're ready as well?
Yes, Your Honor.
Okay. All right. So the way I'll do this is I'll hear from both of you. I'll start with Ms. Connolly, and then you can explain to me not only the reason that you think that there should be an order issued against Ms. Gorin, but since she's also filed against you, you can explain to me why you think that it shouldn't be issued against you. Same thing with you, Ms. Gorin. You can address both of those issues at the same time.
Okay.
All right, and I can sort of keep that separated in my head, and I will decide them separately, but I will hear them together at the same time. All right. Okay, so can I have you both raise your right hands, please? And do both of you swear the testimony that you give in these matters will be the truth, the whole truth, and nothing but the truth?
Yes.
Yes.
Okay. All right, Ms. Connolly, I'm going to let you go first as to both.
All right. So Jordan has a long history of domestic violence, harassment. She is still in an active case for beating up her ex's like new girlfriend or her friend or whoever it was. She has called my place of work, which I have no idea how she found out where I work because I've never had like any interaction about my personal life with her. She called my work and said that she had a restraining order against me and that I show up at her house and bang on her doors and throw rocks at her windows and stuff, which none of that is true. I've never thrown rocks at her window or at her or anybody. She didn't have a restraining order. And then she asked my manager if she could call corporate and tell them the same thing. And again, none of that is true. And then
Where do you work?
The Ram in Lacey.
Mhm.
Um,
Over by Galaxy Drive?
yeah.
Okay,
Yeah, I showed up to work. My manager was like, hey, this girl called and said this, and this.
all right, I got you.
And then she also threatened to come to my house, which again, I have no idea like how she found out where I lived. I do have the videos and pictures didn't send through the email, but the clerk said that I can just tell you or show you if you need.
Well,
But-
you can't show me unless you want me to keep your phone.
okay.
Okay,
But I have a video of her saying that she Ubered to my house in the middle of the night because
Mhm.
she knew where I lived. And again, I've never told her like where I live at all. And then in July, so Joseph, which is her ex-boyfriend or her boyfriend, he told me that in July, Jordan asked if she would be able to beat me up if she tried, like insinuating that she was going to try. And then Joseph told her she wouldn't be able to beat me up. And then the only reason why like I'm still in contact with Joseph right now is because I'm the one who bailed him out. And I know that she's upset that I bailed him out. And then I know that her evidence for the thing against me is like a screenshot of no caller IDs. And I went to my AT&T account and I've never reached out to her like one time. The only time we've talked is either through Joseph or she's texted my phone numerous times, and I have a call log of her calling my number several times, but there's no like outgoing calls to her phone because I've never reached out to her at all. She's also texted me from her phone number and from another phone number. And the screenshots that I have show me saying like, stop texting me, stop texting me, stop texting me. And then the last one, it said like, that I was gonna block the number and then call the police for harassment. And then on the 12th, Jordan threatened to come to my house and break my stuff and ruin my car if I reached out to Joseph's mom, Lillian, which is his sister, or Joseph's dad. And then the police reports that she reported, there's like false accusations in there saying that I showed up to her house multiple times, like in the middle of the night. But I have like screenshots that show that I was at my house with my sister, and she can be a witness too. I was never like, I did not go to her house and throw anything at her or harass her or try to intimidate her or anything. And I have like, I can get my Apple Maps thingy too that shows where my phone was and that I was
So
at my house.
let me ask you a question then, because that's sort of the main point that she made in her petition against you, that you came to her residence in the early hours back on August 10th. So is that the incident you're referring to?
Yeah,
Okay.
or I don't know, but I know that she's made multiple reports that I showed up at her house, but I don't go, like, I don't, the only reason why I even know who she is because Joseph, because I bailed them out. Like, before all this happened, like, I didn't contact her, I didn't do any, I didn't even know, like, who she was. And I think, yeah, I think that's it.
All right, I'll hear from Jordan, but I may need to ask you some questions after that, or
Okay.
I may give you an opportunity to respond to some of what she says, like I said, because there's petitions going both
Right.
ways here.
Oh, can I also say another thing?
Mhm.
So I can't remember the date, but when I first did this, she tried to put the petition on me the very next day, which I think is out of retaliation because I know that her aunt, it works in the court system and she gets all of her information from her aunt. So it was the very next day that she found out that it went through, that she went to the courthouse to get the restraining or the protection order on me. So I feel like that was based off of like just retaliation.
All right, Ms. Gorin, you want to tell me your side of it?
Yes, Your Honor. I did reach out to her job to let him know when I did petition for the no contact order after she showed up to my house. I did reach out and let them know that that wasn't okay and that I would reach out to corporate if further things were going to continue to happen. On August 10th, me and my daughter were woken up in the middle of the night to Lillian Vaughn and Jamie Connolly banging on my front door. And by the time I could even get out of bed to come down the stairs, they had went around, and I have all this on camera of Jamie Connolly at my house on recorded, around my backyard trying to break into my sliding glass door. I have a police report. They called, which I believe is in retaliation over Joseph Vaughn. Joseph Vaughn has 3 assault felonies against me. Jamie Connolly did bail him out. That has nothing to do with me whatsoever. Me and Joseph have absolutely no contact. They called and made false accusations that Joseph Vaughn was there that night, claiming under the influence that he was here. When the police had arrived because I was going to call, Lillian was screaming she had already called. So when I went and opened the door, I had offered the officer, please come in and search the house. You know, if you got this call, I have nothing to hide. Joseph Vaughn is not here. We are not in contact. You know, the officer had free reign to come in and did clear that Joseph Vaughn was not here. They've been harassing me. Those no caller IDs were them because I've answered the phone numerous times. It was Jamie Connolly and it was also Lillian Vaughn doing those no caller IDs. And at this point, I'm just sick of being harassed. She has came to my line of work. She has tried to reach out to my boss, which my boss can write a statement as well. I'm just sick of it at this point. My 5-year-old daughter is terrified still to go to bed when she hears noises because these drunk girls were throwing rocks, trying to bust, literally punching at my sliding glass door in the backyard. Like, intoxicated or not, we're grown adults. I have a child. They have threatened me, like threatened to shoot me. I've never been to Jamie Connolly's house. I had to get her address from the police officer. She still hasn't been served the protection order. And at this point, it's just more of an exhaustion than anything. I don't know how any of my previous relations relate to this. I don't know why they're doing this other than this has to do with Joseph. They have said numerous times that, oh, they're going to get me back for what I did for putting Joseph in jail for assaulting me. And, you know, at the end of the day, they can feel how they want to feel, but they're not going to come to my house and they're not going to do this, or I'm going to take further matters into my own hands as far as having to press charges for, I don't know, breaking into my backyard in the middle of the night, throwing things at my house, threatening me, numerous calls. I've never reached out to Jamie on a fake phone number. I've never reached out on my own number. And if it was way before any of this had ever arisen, and it was not in a hostile environment or situation. And she's the ex of my ex-boyfriend. So I do believe that there is lasting, you know, emotions for this man. Like, she bailed him out $2,500. Like, she realized that he, you know, I don't know, but his sister had said, like, she tried to get back together with him. He said no. She wanted her money back. I don't know if she thinks that something's going on, but we have a no contact order, and I've been following every single rule of that. And after the charges he's facing, there's nothing left there for me. Like, I have a 5-year-old daughter. I want better for me, and I don't want to be dealing with this. This is ridiculous. I don't deserve this. I'm fearful to be here. And the reason I put a no contact order on her, my aunt cannot disclose any information. She never has disclosed any information. I don't even know if she can even get that kind of information, but that was also false. They have been making false accusations numerous times now. And on top of that, I had to leave my house that night because I was scared, because they were saying they were going to shoot me, literally shoot me at my house. They were going to beat me up. They were threatening to beat me up. They were trying to open my sliding glass door while my 5-year-old daughter was screaming, crying in the background. I literally came back, got my things, and left over almost an hour away and stayed with my friend because I refuse to stay here. This isn't the first time I've made police reports, and it's just not coming to an end. And if this all revolves over a guy, she can have him. Like, hands are washed on that situation. I just can't fathom, as a grown adult, doing that in front of a 5-year-old child, intoxicated or not. I've heard in the past that she does drink a lot and she has a lot of issues, and I've been there, done that in my younger days. I'm not perfect. I have a past, and I'm not clueless to that. But that's not where my life is now, and that's not where I want it to be.
Okay. All right. So Ms. Connolly, I'll let you respond to that, and then I'll let Ms. Gorin respond, and then I'll make a decision. Okay.
Okay. I've never showed up to her workplace. She works at a Bikini Barista, so there's no reason for me to go to her workplace to do anything. Like, I've never gone there. I don't want to go there. Like, that's, I don't know. And everything, like, she said that that night she went to her friends, which that's a lie, because on her police report, she said that she took her daughter to her mom's house. So even right then, she was just lying. She's like a serial liar. Like, she's like, I don't even know what to say. None of that is true. I've never threatened her with a gun. Like, I've never harassed her. I've never showed up. She doesn't, like, even have her kid most of the time. Like, her mom takes her kid. If Lillian was here, she could be a witness. I was not there that night. It was Lillian and my other sister. I don't, like, I have proof that I wasn't there that night. I don't really know what to say. None of it is true.
All right. I understand what you're telling me. All right. So, and Ms. Gorin, as I said, I'll give you a final opportunity to respond to any of the things that Ms. Connolly just said.
She 100% did show up to my house. It's on camera, and she 100% has showed up to my job. She has continuously harassed me. She will not leave it alone, and I just am done. Like, I just don't want this to continue anymore. I don't want her to be coming to my residence. And yes, that night I left and went to my mother's because that's what the cop recommended. The reason that my protection order wasn't, by the way, and I did reach out to her and say I was getting a protection order. So that's probably why I told her, I said, I left town. This is ridiculous. I'm getting a protection order against you. She then went and got one while I was out of town. So if anyone is retaliating anything, this is absolutely ridiculous. The only reason I'm here is to be able to protect me, myself, and my daughter. And at the end of the day, All of this is absolutely uncalled for. If this girl does not stop, I will be pressing charges for breaking and entering into my backyard. I will take this further. I do not want anything to do with this person. She needs to leave me alone because if she comes on my property again, I'm not dealing with it. I'm not.
Okay. All right. Thank you. All right. Now, I also want you both to know that I did read and review the petitions that you submitted and the statements that went along with that. And honestly, it's very difficult to find any of this credible. I mean, in the sense that your accusations against each other don't, neither one of you is presenting with more credible accusations or descriptions of events than the other. It's difficult to sort through what may be true, what may be embellished, what may be untrue. What I can tell, obviously, is that there's a lot of, I guess, bad feelings. There's clearly not a warm relationship between the two of you. That's obvious. But I can't stress enough that, you know, this is a legal proceeding. There's law that governs this. This isn't like school or something where, you know, you can go to the principal's office and the principal can make a decision based on, you know, what he thinks should happen based on how difficult you are to manage. It isn't like that. Each of you as a petitioner in a legal case has brought a lawsuit against the other. And the law has specific requirements that have to be met in order for the court to give you what you're asking for, which is an order against the other person. And those are not consequence free. Those orders don't just say, well, leave each other alone. They say that, and they say some other things, but there are consequences. Those orders, when they're put in place, if the restraint provisions of those orders are violated, those are criminal offenses that people can be arrested for, go to jail for. It's serious business. It's not just about people who aren't getting along. It's not just about some guy, as you said, Ms. Gorin. You know, it isn't as insubstantial as that. All right. So it has to be taken seriously. I cannot make findings that basically would say, I think it's better if you stay apart from each other. I do think it's better if you stay apart from each other, but that isn't a legal basis to issue an order against either one of you. And so for both cases, as I said, I do not find a credible version of events here. And I do not find that any of the elements of unlawful harassment have been met in either case. And therefore, both of you are being denied protection orders at this point. Now, I'm basing that on the record, which is the material that you filed here and the testimony that you've given here. If there's other stuff, if there's other, you know, I've heard references to other people who have information. I've heard references to videos and recordings, but none of those things are part of the record in this case. All right, so I'm not considering those things as part of my decision. I just want it to be clear to you that coming here to court for something like this is not a matter of just whether it's a good idea that people who are hostile to each other should stay away from each other. It's a legal proceeding and there are legal requirements that have to be met and they have not been here. So I'm going to give you both copies of my decision, the final decision in this case, which is ultimately it's a denial of the request for the order in both cases.
So, Your Honor, if she comes back on my property, do I just call the police again, or what do you recommend I do?
I'm gonna say this to both of you. First of all, you have to decide for yourselves what you're gonna do. I can't guide you through that. Second, if you believe that your safety is at risk, don't hesitate to call 911. That's what it's there for, and the police would rather come and not be needed than be needed and not be called. Okay, and then if further things happen that you believe constitute harassment and would entitle you to an order, you're free to file another petition.
Thank you, Your Honor.
For the evidence for her calling my workplace, would I be able to just get like a written note from my manager, or will my manager have to come here?
I can't answer that question. All right, so Ms. Gorin, the court clerk is going to send you your copies of the court's orders by email. And then Ms. Conley, since you're here, you'll get your copies right now.
Thank you so much, Your Honor.
All right, those copies will be ready for you in just a minute. And Ms. Gorin, you are free to go whenever you'd like.
Thank you, Your Honor. Have a great day.
So Ms. Williamson,
Yes, sir.
looks like you're here on the charge of simple assault, domestic violence related. I'm looking at what's known as a stipulated order of continuance, which tells me you'd agreed to continue this matter without a finding for a period
Yes.
of 1 year to dismissal.
Yes, sir.
There'll be a monitoring fee involved. You're to have no criminal law violations, don't possess a firearm or other deadly weapon. There is a no contact order in place. Is that going to remain?
Yes.
Yes, I've been told. And then complete an 8-hour anger management class. Do you understand that?
Yes.
You understand if you do those things, at the end of a year, this will be dismissed?
Yes, sir.
Do you understand if you fail in any of those things, you'll be brought back before the court. Your guilt or innocence will be determined by a reading of the police report. So what's happening is you're giving up your right to a trial, but you're getting the opportunity to have this dismissed so long as you comply with all those conditions. Do you understand that?
Yes, sir, I do.
And you concede there are facts sufficient within the police report to find you guilty?
I don't agree, but yes, I guess.
But I understand you might not agree with what's in the police report, but the facts as they are stated in there would be sufficient to find you guilty.
Okay. All right.
I mean, do you agree with this or not?
Yeah, I'll agree. That's fine.
Okay. And again, you have to do an anger management class, 8-hour anger management class. Have you got a line on how you can go about doing that?
I'm sending her the referral list, Judge.
No,
Mr. Sabian just said he's going to send you a referral list.
that's fine. Thank you.
Anything further from the city?
Nothing.
Mr. Sabian?
Nothing, not familiar with Miss Williamson's case, Judge. It's Miss Kamiri's. But yeah, Miss Williamson, the police reports can only come in against you if you don't comply, and then there's
Right.
not going to be a trial. There's no defenses, anything like that. Just want to make sure you understand. The police
I got it.
reports are there. Okay, thank you.
Anything you'd like to say, ma'am?
No, I felt like this was a crime of passion after finding my husband at a hotel cheating. I just felt like they should have threw this out because he actually hit me also. But, you know, if this is the way the law is written and the way they do things, then I'll just have to accept it. But I don't feel it was fair, but it's all good. Out of 30, you know, I mean, that was a lot. And for us both to hit each other, I feel we both should have been punished somehow. But, you know, I guess I touched him first or whatever by pulling his shirt. So I'm willing, and, you know, I'm willing to accept it. It's fine.
All right, ma'am. This will be continued without a finding for a year to dismissal. Don't have any criminal law violations. Don't possess a firearm or other deadly weapon.
Okay.
Complete an 8-hour anger management class. Can you get that done within the next 60 days?
Yes, sir, I will. I don't know. I'm going for a total hip replacement. I'll be out for a while. I got a lot going on right now. The
All
board.
right.
So I'll try to get it done before then if I can.
Well, I'll give you more time, ma'am. I'll give you 4 months,
Okay, thank you.
which is, turns out by Christmas, so just get it done by Christmas, all right?
All right, thank you.
That's it for today, ma'am. You can get a copy of the, judgment and sentence off the district court website. Good luck going forward.
All right, thank you, sir. Have a good, bye-bye. Do I need to stay on?
No, just a moment, ma'am.
Okay.
So is it simple assault? There was also a malicious mischief. Is that being dismissed? The stipulated order of continuance only said stuff, but the JNS had,
Yeah,
well, that's already been dismissed.
yeah, it's been
Okay,
dismissed.
all right. Give me just a minute, ma'am.
Okay, I'm still here.
Okay, thank you. Okay, ma'am, now you're free to go. You can get a copy of this off the Thurston County District Court website.
Okay, thank you.
Good luck, ma'am.
Bye.
Mr. Gromer?
Yes, Your Honor. Good afternoon.
All right. I'll let you tie your tie. I wonder why you didn't have one on. As soon as I'll put you in the waiting room and let you tie it. Bob, you remember, Bill, you might as well. Maybe Judge McManus had a rack of clip-on ties inside his bathroom door, and he would reach in the door and clip on a tie before he came into court, slip on his slippers and shuffle into the courtroom. And they come out and he'd take it off. Yeah. He also had his robe cut down short like a bat cape because he didn't like the long robe. So his robe just came down just under the bench.
That's true.
Yes, you can do that.
True.
So Andy has some clip-on ties, but he wears them well. All right, let's bring Mr. Gromer back in. Yeah, time to put on his tie. Good afternoon. Can you hear me, Attorney Gromer?
Good afternoon, Your Honor. Yes.
Good afternoon. While we're waiting for you to log in, we advised the defendant of her rights as a tenant in a landlord-tenant case. The title of the case is Village Manor versus Winfrey. The file number is 25121526. Village Manor's manager is here. Ms. Winfrey is here, and attorney James Gromer is here on behalf of Village Manor. This is a demand for non-payment of rent. Rent was $424 per month and quite delinquent at the time of filing. Mr. Gromer, what's the current status?
Good afternoon, Your Honor. The current status is actually much better than at the time of filing. Ms. Winfrey's made several payments in the month of August. At this time, Your Honor, we have $870 in rent still remaining, $200.50 in court costs and attorney's fees, for a total of $1,070.50, Judge.
Well, that's good news.
Yep.
Ms. Winfrey, you intend to stay here?
Yes. I did want to add, I did contact DHS and I'm waiting for my application to be finalized or done processing. I had contacted a caseworker this morning. She said it's not finalized yet.
All right, well, let's talk about that. The law says that you're entitled to one adjournment of at least 7 days. If there is representation that you had requested emergency housing assistance, you may be entitled to a continuance of 14 days. So let's take a look at the calendar. Of course, that will get us into the next month of September. There'll be another month of rent due on September 1st. Either way, we're going to go into September. So let's see what 2 weeks from today gets us. 1 week is Labor Day, so we won't be here anyway. Mr. Gromer, can you do Monday, September 8th at
Absolutely.
2 p.m.?
Yes, Judge.
All right, we'll continue this. Monday, September 8th. Now, if you pay your rent, there won't even be the need for a hearing, but you owe $1,070 and you might as well just add on $424 to that. So you're going to owe about $1,500 to bring your rent current through the month of September. So My advice is always stay in contact with your manager, let her know what your intentions are, and share this information with the DHS. The law says you don't need a judgment from DHS to get the assistance. However, they have a different view of things, and they often actually want a judgment. But if I do find that they're entitled to a judgment, you would get an additional 10 days from September 8th, to either pay the rent or move. So that would take you until September 18th. And hopefully that will be enough money for you to come up with the rest of the rent to pay the balance of August and September. Do you have any questions?
No, sir.
All right, we will revisit this at 2 o'clock on September the 8th. If you paid it all, we don't need to be here at all. But if you haven't, we'll address it further at that time. All right, I think we're good to go. That's the only village matter one for today.
Judge, yes, until I have another one at 2:10.
Oh, 2:10. All right, I'll see you then.
Thank you,
And I'll
Judge.
just put you in the waiting room until then. I'll see you then. Miss Winfrey.
I'll be
you're
fully
good to
dressed
go.
before I get on next time.
Okay, we'll make it work. We were singing the virtues of the clip-on tie that Judge McManus used to wear back in the day. I always slip one of those in your desk.
Yeah,
All
I
right.
took it off for lunch because not to spill, and then it just took me more time. Thanks, Judge.
Yes. Stan, thank you. All right, Ms. Kuzma, I'll see you then. All right, now we're out of defendants. Our next matter is Meadow Lane versus Johnson. Mr. LeBray represents Meadow Lane Mobile Home Village. Mr. Dutka, you may be interested in this as well. You represent some mobile home communities. We had a very interesting session at the district judges conference regarding landlord-tenant law, specifically as it applies to mobile home parks. The whole focus was mobile homes and the rules that apply and the confusion that there is in the law. And there's still a split in the law. After the session, one of the judges from Livingston County sent her take on it and sent an opinion that she had written. Anyway, as you know, the landscape in mobile home communities is changing as they're all getting purchased by large companies, and the world is changing.
Mm-hmm.
All right, let me see what I got. Where's Miss Henline?
Did she, you say Helen? You should just come up. Oh. First. Yep. Be careful out there. It's not.
Good afternoon, Miss Henline. You made it. So I'm glad that
Oh,
you're
you just
here.
don't know the day I've had.
Well, you're here, so very good.
I'm here.
We'll address this in a moment. And here's Miss Bussard.
Okay, that's my other one.
Okay.
Elaine, did you give me Rita Henline's file back? Because I seem to be missing it. All right, well, let's talk to the defendants that we do have. Rita Henline is here and Mary Bussard is here. We are missing our 120 case, which is Ms. Johnson. But I will take them and advise the tenants that we have of their rights under the landlord-tenant statute. That's Mr. Dutka's office phone. All right, Ms. Henline, Ms. Bussard. All right, somebody's got, Rita, I'm gonna mute your phone for a minute. But I think we're getting feedback from her phone. We are. She got two things open. At any rate, you are here on a landlord-tenant matter. In each case, it is a demand for payment of rent. No, Miss Bussard is a termination of tenancy. They simply want you to move. As such, you have certain legal rights. No.
I gave it back to you.
Is it in my tray?
I'll go look.
Might have gotten misplaced. At any rate, while we're looking for Miss Henline's file, you have a right to have legal counsel. If you can hire one, if you can't afford to pay for one, you may ask for assistance from legal aid, and our representative from legal aid, Megan Bauer, is here with us today. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to demand a jury trial. That has yet to happen in my tenure as judge, but it might. If you do demand a jury trial, you have to tell me at this first initial hearing or file the written demand within 5 days and be prepared to pay the jury demand fee of $50 unless the judge waives it. If your landlord has asked you to be evicted from a residential property because you haven't paid rent, you may be able to get assistance from the Michigan Department of Health and Human Services, local coordinated entry agency, a housing assessment and resource agency, that's Neighborhoods Inc., or if you're a veteran, possibly Veterans Benefit Assistance. You do not need a judgment against you to receive the help from the places listed above. Copy of the summons and complaint in your case are sufficient, allegedly. You may be able to reach an agreement with the landlord by going through mediation. If both parties are interested, the court can help set that up. You may be able to reach an agreement with the landlord. That means the case would get dismissed. All right, I'll keep looking for it. And if that happens, we would file or assist you in filing what's called a conditional order of dismissal. All right, let's talk to Rita Henline. If I could find her file. Miss Henline went through this last year. This is filed as a demand for non-payment of rent. Miss Henline called with some concern that she wouldn't be able to get here, and I urged to have her try to Zoom in like she did before, and she was able to do that, so I'm glad that she's here. But I've misplaced her file.
That's frustrating.
Here it is. I found it. All right, this is one of the main things we were discussing at the seminar, whether you could file a non-payment of rent rather than a just cause termination when the person owns the trailer and the company owns the lot. Judge Murphy in Livingston County opined that you cannot. At any rate, other judges have different views of it. So this is filed as a non-payment of rent case when Miss Henline owns the mobile home and Meadow Lane owns the lot. There is another way to do this, Miss Henline. It's called a just cause termination. And then there's no option but to move. And as a practical matter, it's very hard because mobile homes are really not very mobile. But Mr. LeBray, what's the status here?
Well, there's been a lot of non-payment, Your Honor. The total amount that the plaintiff alleges to be due, which would include the additional 2 months of lot rent, $50 a month late fees, sewer and water fees, attorney's fees, filing fees, service of process, the whole
Well,
thing.
all right, take the costs out first. Just tell me what rent, late fees, and sewer and water.
$8,269.33.
That's through 6/2/69/33.
That's through the August rent. That's a current number.
Lot rent, water, and sewer, and that is expensive in Three Rivers. and late fees. This happened before, Ms. Headline. You were very far behind in your rent and they somehow made it work. It almost feels like you haven't paid any rent since then. What's the status here? Oh, let me unmute your microphone. All right, go ahead.
It started back in 2024 when we made these arrangements. And I didn't have any cash then. I had started working for a different company and I had to sell my van to pay the first $1,500, which I did. And then in May, I was finally paid for the month of April from this company, and I was able to pay the next $1,500. After that, I never got paid again from this company. When DeMarcus turned 21, of course, his waiver changed, and he had to go through Summit Point, which I don't know if you're familiar with them. In Battle Creek, they're a mental health facility that a company that will pay his nursing, fees. And the company is loaded with many different people and you never get to talk to the same person twice. I gave them everything they needed. It was very difficult for me because they never taught me how to bill until April, about the 25th of April. And so at that time, that's when I got my first check from them, not until May.
Let me ask this, Mr. LeBray, if you can tell me, when was rent last paid on this lot?
Can you need a file? Can I give you this? I have Lois Holloway. She is the regional manager and she has those kinds of numbers. So if you can wait just a second, you'll check.
I read through those payments and I don't understand any of it.
24, Your Honor.
When? When was rent last paid?
5/17/24.
No payment has been made since then?
No. And when I got involved with social services.
Just a minute, I didn't ask you anything.
Oh, I'm sorry.
I will in a minute. And that was my fear, because this is about a year's worth of unpaid lot rent. Are they correct? You haven't paid any rent in more than a year?
That's correct.
All right. You are, again, in dire straits like we were last time. You're very close to them. Now, there's still an issue that I haven't made a ruling on it about whether you can even do this. But let's assume that you can, and I can order that you pay the rent. If you don't pay the rent, they can force you out of your mobile home. And then remove the mobile home from your lot. And we were close to that. You had to know this was coming. You haven't paid any rent. You were a year or more behind, 2 years behind last time, and you got caught up, and now you've paid no rent since last May, and I don't need to know the reasons for it. They don't want to continue this. You've lived in this home for 40 years or more. But you can't just continue to stay there without paying rent. And it's worse than that. You don't pay the utilities and the park has to pay your sewer and water bill. So do you have any plan of approaching this?
Well, yeah, I was trying to explain that to you. Social services could not help me because they did not send me a legal notice to quit. They just sent me little copies that they hadn't written. And the state wouldn't look at it because it was not a filed notice to quit. It was just a copy, and they couldn't help me.
I have one right here filed June 5th. No, that's in the Johnson case. Let me look in yours. Yeah, yours was filed June 11th.
This year.
Yes.
Okay. And that's what I was waiting for. I've also had no satellite or no internet trying to get through to the state again, and I didn't have a phone either. Yes, I'm struggling. I have COPD,
Yes.
and I'm just dying. Period.
Well, we had this discussion last time around, and I don't really like the outcome, but you can't expect to. Now, there's an advantage to filing it this way, whether you can do it lawfully or not. Mr. Duck and I have had this discussion. Meg Bauer's been on it several times. If they file it as a demand for non-payment of rent, you may be able to get emergency housing assistance and you can redeem it. So if you pay $6,000, you get to stay. If they file it as a just cause termination, alleging there are 3 late payments in a 12-month period, there's no option. They just seek termination of the tenancy. You would have 10 days to move and 90 days to sell or remove the mobile home. So the way they filed it, and this happened a lot during COVID, when there was emergency funding available, I allowed these to go through and people got their rent paid. But anyway, the law requires that I adjourn this matter at least 7 days. But next Monday is Labor Day and we won't be here. So you're going to be another month behind in the rent. And we're going to go to September 8th at 2:10. Does that work for you, Mr. LeBray?
I'll make it work, Your Honor. That was September
8th at 2:10. Mr. LeBray, I will send that opinion that I just received. I'll redact some of it, but I'll send you that and you can review it. But I've been inclined to allow these, whether the law allows it or not. And as I said, there's a substantial debate. I've got a couple of very learned briefs, one from the Aaron Cox law firm and one from another law firm that argue that this is allowable. We had a very vigorous discussion of this just last Wednesday at the judges conference. Anyway, what this means for you, Ms. Henline, is 10 days from September 8th, they got to kick you out of your house. Well, actually, they can not. They can remove your mobile home from the lot. They can't touch any of your personal possessions. The mobile home is yours. They could hire a company to come in and remove the mobile home. It's been there 45 years, and I don't think it's very mobile.
No, you can't move it.
No, so, but again, you can't expect to just stay there without paying any rent. And so I don't know. Ms. Bauer, you have any thought on this?
Judge, I think you hit the nail on the head that they can move the home. The plaintiff, the relief it is requesting is the right to remove the home from the lot. Oh, wait, I'm sorry. Were you asking for my input on the law or on consulting with Ms. Henry?
Consulting with whether there's any benefit of you consulting with this client.
Sorry, I was focused on the legal element there.
Well, as I said, you and I have discussed this a number of times here on the record and maybe even off the record, but
I'm always happy to consult with folks, Judge. Sorry, I didn't mean to cut you.
Well, no offense taken. Ms. Henline, I'm going to put you in a breakout room. You don't need legal advice so much. You need money. And you don't have any money, and they don't wish to keep paying your sewer and water bill. And
They're not.
they're not. So, well, at some point,
Well, you know,
well,
this,
in a just cause termination, Mr. LeBray, you have the authority to shut the utilities off. In a non-payment of rent, you don't. You have to continue to provide the services. But we're considerably behind schedule right now. But I'm going to, Ms. Henline, I'm going to let you speak privately with the attorney from Legal Aid, Megan Bauer, and Mr. LeBray and I will move on to the next case.
If I may add one factor, Your Honor, I checked with the local property manager at Meadow Lane, and she advises, who's here today, and she advises me that the sewer and water, at least to the best of her knowledge, has not been turned off.
Okay, I didn't think it was.
I mean, we didn't have anything to do with it, and we're not aware of it if it did.
So, Ms. Henline, the sewer and water is turned off?
yes, it's been turned off. And I was concerned too about, we have a new company that owns it now. And they're doing things totally different.
Well, you're going to get condemned. The city's going to kind of condemn your house. You can't live there with no sewer and water.
Well, they've been shutting it off for quite a while. And
it's not they, it's the city of Three Rivers.
No,
but
no. It's
the
not.
landlord is doing it?
Yes, absolutely. And
Well,
the thing is, this manager or whoever is this person is not supposedly at the office. This person is like lives in the park, and they have been. I have so many disconnect notices.
Ms. Henline, those are all red herrings. You're not paying your rent. You haven't paid it for a year. So any of those things are side issues, but they can't turn your sewer and water off. But I'll let you discuss this with the attorney, and we've got other matters to address. So I'll assign you to the breakout room. Okay. And we are behind. I think we're going to have a default here in a minute. But
I don't think
there's Ms. Bauer.
I figured she wouldn't.
There you are. All right, assigned to room 1. You should be able to log into it. All right, I've got others. Rita, hit the button that says join.
Okay.
Is it open, Meg?
Yep.
All right, I got more to do here. You're here in the small claims court, which is a separate division of 3B District Court. My name is Judge Middleton. I'm the judge that gets to sit in this courtroom. And I handle almost all of the small claims matters. In small claims court, the rules are different. They're more relaxed than in general civil court. Claim is limited to $7,500. Neither party is allowed to have an attorney in small claims court. There is no appeal from small claims court. Any decision here is final. Either party has the right to remove the matter from small claims to the general division of the court, where you could sue for up to $25,000. But you have to tell me before we start. Once we begin here, any decision is final. Do you understand? Mr. Soto, we're going to start with your case. Susan Keith is here on behalf of Z Smart, and Jovan Soto Perez is here. This is a claim for $2,358 for some stuff we're going to talk about in a minute. Ms. Keith and Mr. Soto Perez, would you please raise your right hand? You swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
I do. The file number here is 251504SC. That stands for small claims. Let me look at the actual summons. Mr. Soto Perez is in a playground or something, so there's a lot of background noise, but.
Yeah, I'm at my kids at school, picking them up from school.
All right, well, we'll make this work. This is a claim for, as I said, $2,358. Jovan refuses to pay for or return the bunk bed. We're asking for the remaining balance plus $100 in field visits. Is that correct, Ms. Key?
It is. We did go to return it, but it was damaged, so we couldn't return it.
Mr. Soto Perez, what's your position?
Well, I never once refused to return it. They just kept saying that they don't want to take it because they're my kids and this and that and this and that. And I told them I couldn't afford it at the moment because I lost my job and I didn't have a babysitter for my kids. So I had to stay home and watch my kids while my fiance worked. And she's on a certain income, and what she was making was just barely enough to pay the bills and get food for my kids and everything. Because we don't have no food, we didn't have no food assistance or anything then. Now we do, but it took a while for them to accept us on food assistance and everything.
Well, this is an expensive bunk bed. It was used. Monthly rent was $133.19. Weekly rent. The total price, I have trouble doing these on a scroll.
I mean, and when I got it, it was a little damaged too. I got pictures from the day that I got it, and it had scratches and little chunks of wood missing. I took pictures when I got it because it was used.
Yes, you were agreeing to pay. Now, I'm always dumbfounded at these, but no one put a gun to your head and made you sign this contract to buy a bunk bed for $2,729. Ms. Keith, how many payments did they make?
They had 32 bi-weeks left. So 64, 18 payments, 18 weekly payments.
They made 18 payments?
18 weekly payments.
So they paid about $600. Now, you said you made field visits and they refused to return it. He says that's not exactly accurate. What can you tell me about that?
They scheduled a return at one point, and we went out there, and his fiance or girlfriend was there, and she refused to open the door and let us in. Said the girlfriend was screaming, "You're not taking it," and refused to open the door. When we were allowed in to pick it up, we discovered it was damaged and we weren't picking it up.
Now, this includes the furniture, the frame, and 2 mattresses?
3. It's a full twin trundle bunk bed.
Okay.
So it's the bunk bed and 3 mattresses.
Maybe not so bad. Well, you own it now outright, Mr. Soto Perez. I find that You owe $2,358.24. You made a contract to buy this at this certain price. You paid 18 weeks. You refused return of it, which might have solved it. Then when they went to return it, it was damaged. Plus, they don't generally return mattresses anyway. So 3 kids' mattresses are not really returnable. I find that you owe $2,493.59. But you own it. You don't have to make any payments on it. It's yours. You currently don't have much in the way of income. I was gonna try to set up a payment. Can you make any sort of payment on this?
Like I said, my fiance, she's barely making enough for the bills right now.
Right, well, your
And-
circumstances could change. I'm not gonna set up a payment plan that you can't pay and set you up to fail. But you signed this contract, whether it was good or bad, not for me to determine, but it's more of a bunk bed than I thought. It's triple, 3 mattresses and the property, and the purchase price would have been $1,700. Weekly rental, substantially more than that. So they met their burden of proof in a small claims preponderance of evidence matter. Are you still at the lot 31 address?
Yes.
All right, we'll send you a copy of that judgment. My suggestion is you call Z Smart when you're in a position to make some payment on this and set up a payment arrangement. But at this point, you own it. You're not rent to own, you own it, but you have a money judgment against you in the amount of $2,493. All right, you're good to go. School started, as dismal of a thought as that is. Miss Keith, we got problems with the others. Z Smart versus Nance, we have no service. In fact, we don't have service on any of these. You can adjourn this 60 days. Mr. Auer, would you come forward, please, and have a seat right up here? All right, the next matter we're going to address is John C. Auer versus Furniture and Mattress Warehouse. Carrie Kling is here for the defendants, and you're John Auer, is that correct?
That's correct.
I'm going to ask that you each
Yes,
please
John.
raise your hand. Do you swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief?
I do.
I do, Your Honor.
All right, I can't see you. I don't like doing this by telephone only, but we'll do the best we can. Mr. Auer contends that he ordered a mattress, California King. And it was firm, and then he said it was soft as a marshmallow. This aggravated my health conditions, and he wants his money back. Mr. Auer, where is the mattress now?
It's still in our bed. We're still sleeping on it because we don't have any way of disposing of it or moving it. Plus, we don't have another mattress to go into the bed frame.
All right, so you're suing for money. Theoretically, you would get the mattress and the money. Now, the company has a different view of things. They filed an answer. And Ms. Kling's contention is, I'll read her letter. The plaintiff purchased a California King Dorian firm mattress on April 16th, 2025. Please see attached receipt and spec sheet. This was a special order as we do not stock California King mattresses in our store. The mattress came in on April 24th, 2025. We delivered it to the plaintiff a few days after that. Approximately two weeks after the delivery, he contacted the store and stated he received the wrong mattress. We told him we would come back to his house and make sure the right mattress was delivered and there was no warranty issue. Our delivery guys went out and checked the mattress and the law tag to make sure that they matched the receipt. The mattress was the exact mattress that he chose. Plaintiff was very uncooperative. This matter is no different from some buying a car and deciding 2 weeks later they didn't want it. They just can't call the dealership and say, we're returning it. The mattress is the one he laid on and he chose himself. There is no warranty issue. If there was a warranty issue, we would take care of our customer. We ordered what he wanted, and that is what he received. Ms. Kling, is that your position?
Yes, it is, Your Honor.
All right, so he came into your store, tested out the mattress, and asked you to order that mattress for him.
That is correct.
Now, you said you didn't stock it. So what did he lay on?
Well, we have floor models of all the different mattresses we have in our store. And we do not keep back stock of California Kings because that's a rare mattress that people want. So we had to order the mattress for him.
So did he lay on a California King in your showroom?
No, he did not. No, we do not floor. We floor queens and fulls on our floor for our floor models.
All right, so what model did he order?
He ordered the King Dorian Firm California King Dorian Firm mattress. He laid on a queen, but we had to order the California King mattress for him. So he tried the mattress out. He tried actually more than just that mattress out. That is the one that he went back to that he decided he wanted to purchase. So that's why we ordered it.
Now, California King is rare because it's big, takes big sheets, takes a big bed frame, takes a big room. What is the size of a California King?
California King is 72 by 80 or 72 by 85. So it's narrower than a king, but it's longer than a king. So yeah, it's very rare.
All right, so he settled on a Serta brand Dorian Firm mattress. Is that correct?
That is correct.
And is that what you ordered?
Yes, that's exactly what we ordered. Yes, the law tag matches his receipt. That's the exact mattress we ordered.
All right, Mr. Auer, they say it's just like you bought a car and you didn't like it and you want it back. They're saying they ordered the exact mattress that you asked them to order.
They ordered it, but that's not what was delivered. The mattress I laid on in the store was fine. It was a good firm mattress. But the one I received was like a big marshmallow. And every time I lay in it, I sink in and I have to climb my way out of the hole that I'm sunk into. And tomorrow morning I go to see a back surgeon because it's been killing my back. And the two gentlemen who came out to check the mattress, the one guy, I don't think he either didn't pass it on to his boss or whatever, but when he checked my side of the mattress, he pushed on it and he said, "My, that's soft." So their people tested it and said it was too soft.
Do you have a warranty?
I don't have a warranty.
All right, well, you don't have a case.
Yes.
Isn't there a Michigan warranty of implied warranty of merchantability?
There is such a thing, but that would mean it didn't work at all. So you lay on a mattress for 5 minutes in a store, you order one. I had this same experience myself. I don't like my mattress and it causes me problems. And I'm gonna order one online. and hope for the best. But then her testimony under oath is they delivered exactly the mattress you asked for.
That's assuming there is no possibility of a defect coming from the factory.
How do we know that? Because it didn't feel the same way as it did when you laid on it in the store?
I didn't lay on my mattress in the store. I laid on the
know.
mattress that was in the store.
So the difference is your perception of what the mattress is in the store.
No.
And your perception of what the mattress is at your house are different. So you're asking.
The one that is at my house is defective.
All right. How do you know that?
Because it's lumpy, it's mushy, it's like a marshmallow, and when I lay on it, I have to climb my way out of the hole that I'm in. A mattress should not be like that. I've never had one like that.
Ms. Kling, what's your response? He said he had no warranty, then you started to say something.
Correct. Absolutely. There is absolutely a warranty, and that was exactly why we sent our guys out there, because we would take care of our customers if there's a warranty issue. I am telling you, Your Honor, we are more than happy to drive back out there. If there's a warranty issue, CERTA will absolutely take care of it. And all we have to do is send them pictures. But when they went out there, when he initially complained, they checked the law tag. My delivery guys came right back to me and said, there is absolutely no warranty issue. It's the exact mattress. They felt the mattress. That's what the mattress was. However, I will be more than happy to send our guys back out there. I'm more than happy to do that, because if there's a warranty issue, absolutely we will take care of him. I mean, there's no question there.
The issue would come from the manufacturer, which is CERTA, rather than the company.
Correct.
There is an implied merchantability presumption in the purchase of goods. All right, that's what we're gonna do. I'm gonna continue this matter for 30 days. He says it's lumpy, it's mushy, and it doesn't support him. And all your guy did apparently is just push it. And what he says and what you represent are different. Maybe drop a bowling ball on it and see what it does. Anyway, I'm going to continue the matter for 30 days. Plaintiff, defendant will further explore the warranty issue.
Yeah, I'll absolutely send the guys back out there. I'll even get a hold of hopefully our CERTA rep, and maybe he'll go out there. But I do know at the time they went out there, they said there was absolutely no warranty issue. Because if there were, then we would have contacted them and would have started taking care of it.
May I say something?
Yes, sir.
Okay, I told you the guy who was looking at it pushed down on my side, and he made a comment that said it was too soft.
Yeah,
now, he didn't tell you that?
I heard, well, you don't have the right to ask her anything, but at least not at this point. Yeah, I heard what you said, and so did she, so we'll come back and look at it. So I'm going to continue this 30 days, and perhaps CERTA will warranty it, or if it is a Dorian firm mattress, and that's what you ordered, and that's what they sent, there may not be a warranty issue, and you may just be stuck with it. All right, let's see. Maybe there's some, right now, the only reason we have a defect is because you say so. You're not an expert in mattressology. You're a person that sleeps on a mattress, and it doesn't feel the same as it did when you were at the store. And they say we sold you exactly what you asked for. Some of the online companies, Helix and some others, you can use it for 100 nights. If you don't like it, you can send it back. I'm not sure what CERTA is, but CERTA is an old time, long time, national recognized quality brand. And I suspect they'll stand behind their product. So 30 days from now would bring us to September 29th. At 3 o'clock. Mr. Hour, will you agree to let them come out and further inspect the mattress?
Yeah.
All right, I'll let you guys work that out, as to when.
Okay.
And they'll come out and take a look at it, further explore your warranty claim, and we'll address this further a month from now. And
Okay, Your Honor.
all right, thank you. All right.
Thank you.
Thank you. I don't want to put it on, your phone number still end in 2280?
Yes.
All right, they'll know how to get a hold of you. Very good.
Okay. Am I done?
Yeah, thanks.
Thank you.
All right, thank you.
Thank you. Maybe we can get some help from CERTA. All right, thank you. That brings us to one case, and we always manage to fit it all in. The one that's left is complicated. Let me get to the actual complaint. Why don't you folks come up and have a seat? All right, what's left, and this is hard to read. Clifford O'Connell and Rhonda Mullins. Wilfred.
Yes.
I said it's hard to read. Wilfred T. O'Connell. Connell. Wilfred T. Connell.
Yes, sir.
And Rhonda R. Mullins of White Pigeon are suing Adam Snodgrass and Nicole Snodgrass. Adam and Nicole Snodgrass are present by Zoom. The Connells and Mullins are here live. The claim has to do with a swimming pool installation project that went awry. They're asking for $5,591. So the first thing I'm going to do is ask everyone to swear an oath. Everyone, please raise your right hand. You all swear or affirm any testimony you're about to give in this matter will be true to the best of your knowledge and belief.
Yes, sir.
There are several issues in this case, and we'll see if we can parse them out. I got an answer about 8 minutes before the case was supposed to start, and it was hard for me to determine what was going on. But let's first talk about this. You own a house out on Burke Road?
Yes, sir.
And you want to have a swimming pool installed there?
We did have a swimming pool.
All right, but you contacted Nicole and Adam Snodgrass to install this pool?
Yes, sir.
How did you find them?
Through Facebook Marketplace.
All right, and tell me about that.
So basically, I just typed in that, in like the search bar, swimming pool installation, and their ad came up. Professional pool liner installation and back filling around your new pool. Been doing this for 16 years, price depending on size. And a few other things, which I've asked you if you're interested. We do travel to parts of Illinois, Ohio, and Michigan. Just depends on where you're located. And then it went on a little bit longer. If you want me to read it, I'll finish it.
No, all right. So that's how you found
So
it.
that's how we found them.
All right. Were you gonna buy the pool from them, or you bought the pool separately and they were gonna install it?
We bought the pool separately and they were just going to install it.
What was the size of the pool? This is an above ground pool,
It's an
correct?
above ground, it's a 33-foot,
Circular?
yes.
All right. In the state of Michigan, you need a license to install a swimming pool. It's under the Michigan Maintenance and Alteration Contractor License. And it's less than a builder's license, but you need a license. And people are doing this all over the place without a license. You need a license for carpentry, concrete, excavation, insulation work, masonry, siding, roofing, screens, storm sash, gutters, tile and marble, house wrecking, swimming pools, basement waterproofing. We got all kinds of people that are installing roofs and putting gutters on. They call themselves home handyman. If you need a license, you need a license to install a swimming pool. If you don't have a license, you can't sue anybody for your loss, and you can't very well defend yourself for one. So they're doing a license operate, it's actually a misdemeanor. Hasn't been charged since I left the prosecutor's office 25 years ago, but it is a misdemeanor to do these things that require a license without a license. So, Mr. and Mrs. Snodgrass, you have a residential alteration builder's contractor license in Michigan?
No, I've actually talked to cops about this too, and they said as long as I said I was a friend, then I could do it.
And we made them well aware that we only do it on the side. And the gentleman that we brought with us, he actually is licensed and bonded.
All right, who's that?
Jonathan Bragg.
Is he licensed in Michigan?
He was. I mean, he had licenses for Michigan, all of Indiana. I mean,
Ohio, Illinois.
License as what?
His business name was A1 Pools and Spas.
All right, you don't have a license to do this, but that doesn't mean they get everything they asked for. They threw everything in but the kitchen sink in here.
I know, that's what I'm saying. I gave him a deal to start with. I mean, at first it was supposed to be 3,000 and they said no, so I told him 1,200.
If they were willing to help us do the work.
And then we got out there, the ground wasn't done like they said. We had to change the bricks because they had small bricks. I tried to do everything as professional as I could, sir.
And another thing was
stop. I didn't ask you anything yet. All right, so how much was the contract to do this job?
1,200.
No, I'm asking now.
Oh, okay,
So
sorry.
you contracted with them, they were gonna come install your pool for $1,200?
Correct.
We paid him $1,200. Red receipts.
All right, then you list how things all went sideways here. This was dumb, finding somebody over the internet on out of state. They're not licensed. You can check with a license or you can ask around. So anyway, they seem like nice folks. They need some money. They come to your house. They're going to install your pool. Tell me what happens.
So they come, I believe it was a Tuesday night. I don't know. It was the first night. It was May 31st, whatever day of the week that fell on. They showed up. We had been shoring with Shoring Concrete. It's my stepdad. We had him come in, laser level our poles, our things. So everything was laser leveled out. Other than we didn't use 6-inch by 12-inch bricks. We cut them in half and put them directly under each, there's like a little metal plate. They wanted to change that when they got there, which was fine. They said the weight would just be better on a full block. We had the blocks there, we changed. We all run around changing them. So it wasn't like we were very willing to help.
I took their word as being professional, so whatever they said, I was good with it. And the price they gave us was a good price, so I'm assuming, we're trying to help them out. You could tell.
Well, what you get is you get your $1,200 back. The fact that you had to pay somebody in to come in and properly install the pool, and you want them to pay for the water. Well, so when you had to redo it, did you lose all the water?
So what happened was we had Mike Taylor come in, and there's a letter that Matt Taylor, yeah, he wrote a letter. Basically, when we installed it, he got the second tanker in, and our liner dropped on the liner, it dropped on the one side. And he stopped. He's like, I can't put any more water in this. They've got to come back out and fix it. We set up 3 different appointments for them to come out. It was, we can't have a ride. My mom won't do it. My sister won't do it. And they just finally never came back out to help. So me and him took.
Well, they told us to use a heat gun in a pool full of water, you know, electric heat gun and heat the line up and stretch it over ourselves. There was too much weight where the water goes. So common sense told us, you know, we did make a mistake made by the way we found it, and I'm sorry, you know. We tried to help them out, but we had to drain $600, $650 of the water out.
I told you I was gonna come fix it though, sir. I did. I was on my way and you texted my wife and said not to come.
And we said not to use a water truck for that reason. I was gonna have you guys sign off and you refused.
I was talking, so.
All right, yeah, so we're,
Nowhere in the contract. does it
stop,
say- okay.
stop. This job wasn't done well. You don't have a license. You caused them a lot of aggravation. They paid you
They did
$1,200.
character on us all over Facebook too.
Say that again?
They actually called my probation officer and then they wrote on our Facebook page that we were bad, we didn't come late. They just slandered me said I'm a thief, all kinds of stuff on Facebook. And they called my probation officer and told her I was out doing drugs and everything.
Well, I don't know about any of that, but
I submitted the proof of it.
yeah, you sent me a bunch of stuff about
Amanda.
2 minutes before I started. I didn't have a chance to read it
I don't
carefully.
even know who Amanda is.
Yeah, I don't know who Amanda is.
I never said Amanda.
And then that thing was
You can't be
the lady was gonna go with us, but then she saw her review of what Rhonda had posted. That's who Amanda is. Once she read that Rhonda made that post, she decided to not go with us because of Rhonda's post.
I mean, all my other reviews are 5 stars.
All right, well, I can't
And
speak
the
to
job
that.
was
but You're not
done.
licensed. You're not licensed to do this in the state of Michigan.
Arguing with the judge.
I'm not the pool was put up. The only thing we had left to do was come back and put the skimmer on. And then they didn't listen with the water truck and that slipped. We were on our way to come fix it. They told us to turn around and not come.
You're screaming when you stop.
Kim, I don't have a judgment here. I don't know if I misplaced it.
And I
Can I say something, sir? The
Yes,
contract we got doesn't say anything about not using a water truck. Our water is
No,
rusty.
when the job was done, all three of us
Miss
told you guys.
Snodgrass, Miss Snodgrass, we aren't sitting around the kitchen table. We're actually in a court proceeding. This is a trial. So it was his turn to talk. The lawyers don't do that. They don't, most of them don't shout over each other. I'll give you a chance to say something, but this is his turn.
Okay, nowhere in the contract does it say not use a water truck to fill it. We have pictures of the water truck, how soft and easy to fill them up. They do it professionally for a living. Our water is rusty at our house, so we understand that. So we decided to pay for the water to get brought in, which everyone
Did I
knows.
lose it? Yeah.
Which a lot of people do that, which I do that, and it saved us hundreds of dollars in chemicals.
They use a 4-inch elbow when they go to pump the water in. They don't pump it full blast. They invert it up so the water goes into the air like a mushroom, and it wasn't going in it. I have it on video if you'd like to see it. It wasn't going in at a big force. The biggest issue now that we have with the improper installation is back over where the skimmer is at. The poles that are there are actually buckling because the way the liner was improperly installed. It was, 12 inches hanging down by the skimmer, and then every little area of the pool was different sizes.
All right, there is something that I can't find what you refer to as a contract, but you paid $600 down and paid them another $600. So you paid them a total of $1,200.
Correct.
They said they weren't done, and I took their word for it. And, I took the word as humans, as a grown man. They said, we'll come back. We really need the money, I'm assuming. So I trusted them, I'm not trying to be a rude person here, but, I trusted them. We've eaten and fed them. We cooked food and fed them. But the time they're out in our driveway arguing and fighting, our neighbors come over concerned, wondering what was going on.
Yeah, there was some of that, but she took off. At any rate, what you get is you get your money back.
Okay.
And
That's what I'm
what you
saying,
get,
sir.
you get paid $1,200 for doing this business in Michigan when you don't have a, yes,
I have no
I saw that,
problem.
but I didn't configure that was a license.
I have no
No,
problem
that's-
paying them back, sir.
What's
It's
that,
just that
sir?
I have no problem paying them back. I just didn't want to pay the 6,000 they're trying to sue me for.
Because
Well,
they
I
did
ordered
do us wrong too.
$1,200. Can you pay that at $100 per month?
Yes, I would be willing to do that, sir. That's what I'm trying to, you know.
All right, well, $1,200 plus $102 in court costs, that's $1,302 payable, that $100 per month.
What
Starting
was the total?
What was the total again, sir?
$1,302.50.
Okay, and do I have to call them to set up where I'm sending it to, or?
Yes, you do, but you'll send it to their Burke Road address. I would suggest
Okay.
you send a certified check or money order, get a
Yeah.
postal money order or a Walmart order. I'm gonna
Yeah.
have you to start paying it by, can you pay by September 15th?
Yeah, I could probably start on the 3rd of this month.
All right, I'll take it
We'll
to
go
15th.
with the 15th.
Well, we'll go with the 15th, but they might get it early is what I'm saying.
That's fine. And if you want to pay early, you can pay it off early and just be done with it. But as long as you pay $100 per month, I don't know what your status is in Indiana, but you're not licensed to do this in Michigan.
I'm just gonna stay away from Michigan and stuff because, like I said, I've never had no problems doing this.
All right, that sounds like a good plan. All right, I ordered you to get your money back, but not the rest of your damages, and they're gonna pay it $100 per month starting September 15th or sooner.
So if we don't get paid, then what do we
You
do?
contact the court and do what's called a discovery subpoena. They compel them to come to court.
I feel it's fair enough.
All right, the court officer will take you out. You get a copy of that. Mr. Snodgrass, are you at,
Yeah.
We have a different mailing address.
well, I don't want to put that out over the live stream, so let me stop that.
Okay.
Are pending in the District Court of Butler County, Kansas, both State of Kansas versus Quentin Lawrence Height. They are case numbers 2025 TR 1215, 2025 CR 261. Jared Regier appears on behalf of the Butler County Attorney's Office. Quentin Height appears by Zoom, apparently still representing himself. These matters come before the court at this time for review of status. Mr. Regier, have you had any discussions or negotiations with Mr. Height regarding these matters?
Your Honor, the state understands that a plea offer had been previously advanced to my office. I cannot speak any more beyond that at this time.
All right, so I'll ask Mr. Height then. Is there a chance that these cases may be resolved by dismissal, diversion, or plea agreements reached with the county attorney's office?
I would be open to making some sort of agreement with the county attorney's office. I would continue to seek some administrative remedy, yes.
Okay, well, I'm not sure what you mean by the administrative remedy, but Mr. Regier, would it be helpful if we put you and Mr. Height in a breakout room to perhaps discuss the status of these two cases to see if there's some accord that could be reached?
Your Honor, based off my notes, it would appear that as recently as last week, my office had communicated with the defendant regarding a possible resolution of both these matters by plea. Based off my notes, the state understands that there has not been a successful meeting of the minds in this matter.
Well, we're going to try to get you two together today. So I'm going to recess these proceedings and let's put Mr. Regier and Mr. Height in a breakout room. Just have a brief discussion to see if there's any common ground that can be reached. And if not, then we'll come back and do further business.
Very good, Your Honor.
All right. So we'll pause recording and broadcasting, Mandy, and let's put Mr. Height and Mr. Regier in a breakout room. Mr. Regier, Mr. Height appearing as before. Following this conference, which the court initiated, is there any announcement to be made regarding resolution of one or both cases, Mr. Regier?
Your Honor, the state understands that my office has again offered a resolution to the defendant. However, the state understands that there has not been a meeting of the minds in this matter.
Is that correct, Mr. Height?
I have produced an offer on my behalf as well, and so we both made offers, and yes, a meeting of the minds has not been met.
All right. I trust then that you wish to go to trial on these matters, Mr. Height?
Not at this time. I'm not sure if you've been made aware, but I have requested a subpoena via a precipice that I provided to the Butler County Clerk on August 14th. That was directing them to subpoena records from the Butler County Sheriff's Office with a production date of August 22nd at 5 p.m. That date has come and gone now, and I am still waiting the subpoenaed evidence that directly affects these charges. However, via some hearsay this morning on the phone with the Butler County Clerk, I was informed that the sheriff had motioned to quash the subpoena. I'm not personally received anything in writing as of now that shows why the sheriff would want to quash a subpoena. As such, I'm moving this court to continue this matter until I've had ample time to review and respond to the quash.
What type of materials were you requesting from the county attorney's, the sheriff's office that they haven't provided?
Sure. Body camera. I can read it directly. If you can give me just one moment. It's
well, I'm just wanting to know generally, perhaps not every detail, but
yeah, I wasn't going to read every detail. I have it right here. So that would be some policy in regarding to the Butler County Sheriff's Office policy and procedural manuals, some core policy, procedural directives, training requirements, special orders, general orders, and operational guidelines, and any updates since the arrest till now has happened. Also, all body-worn camera, dash camera, and in-cruiser footage from the time of the incident, and any and all officers, some information in regards to them, as well as probable cause affidavits, and also any further information that may be deemed necessary and pertinent to my cases.
Did you make a discovery request to the county attorney's office to see what documents they're relying upon?
I have not at this time. I subpoenaed it to the sheriff directly to receive the full entirety of the evidence.
All right. Mr. Height, you're proceeding at least to this point on your own. Is it really your intention to represent yourself on these cases, or do you want an attorney's assistance?
I am not looking for an attorney's assistance.
Okay, well, the court doesn't advise you to represent yourself in court for several reasons, Mr. Height. Lack of legal expertise is one. Representing yourself requires a deep understanding of the law, which isn't always available to someone who's not law trained. Second of all, you might be prone to make emotional decisions that would cloud your judgment rather than to make rational decisions driven by logic. Further, procedural missteps often happen by someone who's representing themselves. Even minor mistakes can have a significant consequence, like missing a filing deadline or failing to follow proper procedure in court. Do you understand that, Mr. Height?
Yes, I appreciate the notes. Thank you.
Well, further, there's the potential for severe penalties. Handling your own defense can lead to severe penalties, which include fines or imprisonment or permanent marks on your record. Do you understand that?
I do.
Now let's go over that. Well, we may have already done this once, but interference with law enforcement, as you're charged in case number 261, is a Class A misdemeanor punishable by up to a $2,500 fine and up to a year in the county jail. Do you understand that?
I do.
You understand that in count 2, failure to register a vehicle, an unclassified misdemeanor, is punishable by up to a $500 fine and up to 30 days in the county jail, or both.
I acknowledge.
All right. Further, in your other case, the 1215 case, you face a charge in count 1 of no driver's license in possession an unclassified misdemeanor, again, punishable by up to a $500 fine and up to 30 days in the county jail. You understand that?
I'm aware.
And last, but certainly not least, failure to register a vehicle in count 2 in that case is also an unclassified misdemeanor punishable by up to 30 days in the county jail and up to a $500 fine, or both.
Thank you for making me aware. I appreciate it.
And I also want to point out to you that if you proceed to trial proceedings on your own, that there's usually difficulty for a pro se individual to present evidence. Certainly, legal assistance would be very, very helpful, especially when it comes to witnesses or presentation of your evidence in court. It's often very difficult for someone who's not law trained. You understand that, Mr. Hyde?
I appreciate it, yes.
And knowing all of these things, you still wish to proceed without a lawyer?
That is my intention.
And you do understand that if you can't afford an attorney, after proper application, the court will appoint you a lawyer to represent your interests.
I am aware. However, I would like to also make it known that I am still trying to move for getting this evidence production figured out before I am able to enter a plea. It would be inappropriate to plea without my knowledge of these proceedings beforehand. So that is why I am moving the court for the, specifically speaking on the traffic case, to move for continuance in order to be able to discuss further with the prosecution as well as the sheriff's office and the court, if necessary, to receive the evidence that I need to move forward.
Mr. Ricke, is your office in receipt of and or familiar with this subpoena and the motion to quash it?
One moment, Your Honor. Your Honor, I am not aware of any such document, although it would appear that a written objection to defendant's subpoena dulcis tecum and motion to quash was filed with the court last week by Butler County Councilor Terrence Hulskamp.
All right, so it's obvious to the court that he will be handling anything in relation to the subpoena dulcis tecum request, correct?
That would appear accurate based off the filings, Your Honor.
Your Honor, if I may, I do have a receipt of delivery to the court as well as the prosecution for the subpoena dulcis tecum. So I did make them aware. If there was a clerical error within the office, I apologize for that being the case, but I did do my due diligence to make all parties involved available to be aware of the subpoena dulcis tecum that I was to be served upon the sheriff's department. I'd also like to let the record reflect that I do not have a copy of any thing that the sheriff's department or Mr. Hulskamp that may have filed in regards to a whatever motion. I've, like I said, I have hearsay from this morning from the clerk, but I do not have anything in writing at this time. So it'd be inappropriate for me to act accordingly as if I knew what the material had on it.
All right. Mr. Hyde, probably some of these requests could have been handled with proper discussion with the county attorney's office. They're usually quite liberal in their turnover of documents in the case, at least anything that's within their possession.
Sure.
If we do have a motion to quash in this case, we'll need to have a hearing on that. I'm inclined to set that as an in-person proceeding on Thursday, October the 2nd.
Just one moment, please. Thursday, October 2nd. And would that be in regards to both cases or one specifically? I do want to make sure that we're there's two separate cases here, and I'd like to be able to speak clearly to both of them separately.
All right. So your request for information pertains only one of the to one of the two cases and not both?
I submitted nearly identical recipes as well as subpoena duces tecum for both of the cases. So they would have been served and compiled in very similar manners, requesting very similar records.
All right, both of these cases are assigned to this division. They will be essentially handled together to the extent reasonably possible, though obviously it may be necessary to try the cases separately eventually. Both cases will be set for not only determination of any discovery issues, subpoena issues, if you will, but also for further a determination of status and for further scheduling. So, Mr. Ruggiero, I will need a representative from your office pending, even if County Councilor Hulskamp handles the subpoena issues. Yeah, I'll need a representative from your office on Thursday, October the 2nd, and I'm contemplating 10 o'clock a.m. for that
Very
hearing.
good, Your Honor.
Fine. All right. 10 o'clock a.m., Thursday, October 2.
And
we'll
that would
sort out
be
this subpoena issue and any issues related there too.
And what are you titling this hearing again? I'm sorry.
Well, it'll be a hearing to determine whether this court should recognize and continue the county's motion to quash. Court will make appropriate rulings regarding that. And then do further scheduling and status review as to where these two cases stand. Certainly nothing precludes the parties from having further discussions to try to resolve these issues on their own. For now, it does appear that the defendant in this case has rejected any request for appointment of counsel and apparently does not have any intention to retain counsel. So he'll be representing himself at this juncture, despite the court's admonition and warnings otherwise. So 10 o'clock, Thursday, October 2, Courtroom B, Butler County Judicial Center, El Dorado, Kansas. The
Very
county
good.
counselor's office will be so notified.
Judge, I do have one further matter, if you just one moment, please. And also in regards to the subpoena, I have been in discussions with the Butler County Sheriff's Office, and they have been quite receptive to my discussions in regards to evidence production from this case. I wanted to make you aware that I have been in discussions with them, as well as the prosecution in the limited capacity that Jared and I have been. I'm just making you aware so that it may be clear that I have been working outside of the court as to try and not burden the court for these hearings. Initially, I'm trying to seek remedy, as I was mentioning earlier, outside of the court, and that would be my intention. So just trying to make you aware of such happenings.
Who have you been discussing these matters with at the sheriff's office?
I have received information from I'm not sure of their title, but the administrative person at the front desk.
Okay. Well, probably the person that should be your contact person at the sheriff's office at this time should be Terrence Hulskamp, the county counselor. He does represent the sheriff's office interests in matters such as this, and I think he's the one that actually caused the motion to quash to be filed. So you probably want to deal with him.
May I have his name, spelling of his last name, as well as contact information if someone has it available?
I don't have his contact number available, but I can spell his name for you.
I will
His
take
last
that.
name is Hulskamp, Huelskamp. I think that's what it is.
And he is the, do you have a title as well?
He's the county counselor.
County counselor.
Yes. He's obviously a lawyer.
Yes. Thank you for that. Okay. I am in receipt of spelling of the last name and his title. I will, I suppose I will call the attorney's office to try and receive contact information for him and continue the discussions with him. I hope to be in receipt of any filings that were mailed to me on behalf of the sheriff and or prosecution via the court in the next in the coming days, and review as such.
All right. And you do understand, Mr. Height, that you'll need to be in the courtroom, courtroom B, Butler County Judicial Center, for this next proceeding.
Courtroom B,
B.
and is that B as in boy?
Correct.
And is that available to me via the main entrance, and then I'll be directed as I get inside?
Yes.
Okay. I'm just trying to be clear about everything, make sure there's no hiccups.
You'll have to check in through security
Okay.
desk, and they'll tell you where you need to go. If you don't know, they'll show you the way.
I appreciate that. Okay.
Mr. Regier, anything further from the state's perspective at this time?
No, Your Honor.
Okay.